Good afternoon, Long Island, and welcome to the fall 2022 return of Long Island Business News' webinar series, LIBN Now Experts Forum. This platform, which is streaming live right now on Zoom and Facebook, delivers the most relevant information on topics affecting your business within the Long Island community. Now, today's topic explores planning for a loved one with special needs. From disability and Medicare planning to guardianship and even general support, there's so many details to untangle when making plans today for tomorrow, and many pitfalls that could affect your loved one as well as your family. Luckily, LIBN has recruited 3 experts to share their perspective on how to navigate this unique form of family planning. Joining us today is Mary P. O'Reilly, co-chair of the Trust and Estates Practice Group at Meltzer Lippy, Goldstein, and Brightstone. Laura M. Brancato, partner of the Elder Law Litigation Practice Group at Meltzer Lippy. And Charles Bannock, executive director at Mary Haven. And moderating today's discussion is LIBN's very own editor and associate publisher and my good friend, Joe Dowd. Thanks so much to each of you for joining us today for this conversation and for joining us on LIBN Now's kickoff for the fall season. Joe, take it away.
Thank you, Jenna. And thank you to our guests for joining us on LIBN Now. I want to open with this question to the group. The State Health Department survey about a decade ago indicated that about 1 in 5 New Yorkers, that's 3 million people, reported having a disability due to an impairment or health condition. Now, the difficulty with this enormous figure is exactly defining what constitutes a disability. In some definitions, a disability means needing assistance with basic self-care issues. So I want to open up with the idea of what portion of our population are we talking about? And at what point do caregivers have to say, I need help? We have experts for this, and I'd like to open with Charles on this one. Can you give me an idea how big an issue this is and how it affects Long Island?
As you know, Joe, we deal primarily with intellectual disability, and the abundance of adults with disability is tremendous. There have been initiatives over the years, starting with Governor Pataki, to try and find appropriate residences and services for individuals with intellectual disability. Recently, there's been a second initiative in order to find adequate residential placement across the region because the numbers are just astronomical. So a provider like Mary Haven, who can provide a number of services, including residential, day service, have become paramount to families who are experiencing a real strain in the home environment. You typically have 2 working parents. You're hoping that your individual will attend some type of day service where they're occupied while parents are at work, but the true work begins when they get home. And we'd like to get the message out to families that there is an alternative. And we now belong to a network of other providers called Connection that truly provide a continuum of services over one's lifespan. So there isn't a service within our network that a family could not access for their loved one.
Okay. Mary and Laura, as lawyers, tell me from your perspective how big a problem you're seeing. Let's start with Laura, please.
Sure. So Charles touched on one point of disability. Intellectual and developmental disability are certainly a significant portion of the population, but to get the real definition of disability, you have to refer to the Social Security regulations and guidelines. All federal and state disability guidelines are determined through Social Security's definition of disability, which can include various types of impairments, including physical disability, individuals who need help maneuvering in a physical manner, We also have individuals who suffer from cognitive impairment like Alzheimer's, dementia, individuals at late stage Parkinson's or ALS. Those individuals are also considered disabled. We also have a pretty wide segment of the population that's disabled by reason of mental health condition, permanent or severe mental health condition, and or addiction. Individuals who suffer from severe addiction issues, especially long-standing issues, can also be declared disabled under the Social Security regulations. So the population that's affected by disability, probably within the next 10 years, I know the Alzheimer's Association has tried to get a more accurate figure. It will be 1 in 4 people on Long Island will be affected by disability, either themselves or somebody in their immediate family who needs certain levels of care or who needs the type of legal planning that Mary and I specialize in at Meltzer.
And Mary, please.
I was going to say, one of the challenges is, right, it's not a static definition or a situation somebody has. You could have somebody who's very capable and living a productive, successful life. And, especially, the Alzheimer's, diminished capacity starts to creep in, and it's a really hard time to find the exact points, right? When that happens, you see somebody slowly deteriorating, and it's a struggle to kind of get the family involved and to even the person themselves who is, the victim of this illness to even recognize it. And so there's a lot of tension, particularly for these later in life impairments.
1 in 4 is a staggering number. I mean, it actually kind of blows me away. I would imagine that there is much to consider when planning for long-term needs of a disabled child or an adult. These topics can include things like guardianships, special needs trusts, disability planning, Medicare planning, and the importance of qualified fiduciaries. I would imagine you need lawyers too. Mary, can you jump in and tell me the kinds of roles that are necessary and what people in our audience need to know about the options available to them?
Yeah, so if you have somebody in your life, most often what we see is either a parent who has a child who has special needs, or a child who has a parent who's becoming ill with Alzheimer's or other incapacity issues. And so, they come to us and just want some guidance, what can I do? And there's lots and lots of things to do. I think one, you touched on the concept of fiduciary. And so an important role that you can have is naming somebody as their guardian, and to kind of take over and make decisions for them. Laura, I don't know if you want to, touch on
Sure.
the different options there.
Yeah, so for purposes of this discussion, I think especially in Charles's world, we're talking about individuals with intellectual or developmental disability. New York State separates out, there are 2 types of guardianship in New York State. And so we have to narrow our focus a little bit. Individuals who become disabled or incapacitated later in life are generally dealt with under the mental hygiene law. We do guardianships in that realm. But for purposes of today, we really focus on what are called 17A guardianships, and those are proceedings over individuals who have been declared disabled before the 22nd birthday. So individuals who were either born developmentally or intellectually disabled, or who were diagnosed in their grade school years, things like that. And the court differentiates them because the needs are usually very different. And so for purposes of today, guardianship in New York State is rapidly changing. The concepts surrounding guardianship are changing. The governor signed a law into effect in May of this year, which will really change the landscape of guardianship. And what's important for this audience to understand is that guardianship should be seen almost as a last resort for individuals on a spectrum. Let's say it's easiest to talk about in the autism spectrum world. Individuals who suffer with autism can vary so much in their presentation and in their ability. We don't say that any one condition automatically qualifies for guardianship. You have to look at each individual child or adult to determine whether guardianship is appropriate. And that should be done in consultation with an attorney who's experienced in this area. I like to say, particularly not an attorney with a laundry list of specialties. that are unrelated, like criminal defense or, construction accidents. This is really something very specific, and a special needs or estate planning attorney should really be involved in this process. But guardianship can be a very useful tool for parents and other loved ones, siblings, cousins of individuals who are going to be asked to take care of somebody through their adult life. So it is an important consideration, but we need to be careful that we don't initiate guardianships unnecessarily over individuals who may have the ability to make certain decisions for themselves as they move through life.
Well,
And
If I could mention too, from the provider perspective, and making difficult life decisions, we find utilizing a circle of support is much more effective. So you have people that are quite familiar with the individual. You have typically a service coordinator, or they call them now care managers, in play, families in conjunction with the workforce that are working directly with the individual. So a guardian in most cases we find is not as necessary unless a family is getting on in life and can no longer take on that degree of responsibility.
Mary, you were going to say something.
yeah, I was going to say, and there's various, as Laura says, it's something that we look to as a last resort, and there's various, legal documents that you can empower other people to act for that person who's in need. So, a power of attorney, a healthcare proxy, where somebody can manage your finances for you. You don't have to go through the guardianship. I think a lot of parents, hesitate. They want to empower their child and show them that they're capable. And so I think there's something of a struggle to want to go forward with the guardianship. And I agree that it should be, a last resort. And so another piece of it is, managing property for that child, and you can do that through a power of attorney, or which something that comes up in our practice all the time is, families are planning for when they're not going to be there for their child, right? What's going to happen when they're no longer here? And so, that to me is one of the key parts of this planning. And it's something that really should be done very early on. It is not the type of thing that you want to wait and just hope for the best that the plan you put in place works. And so we find that, the most successful way to do that is starting while you're very much alive and well and involved in your child's care, and really building a network around you of people that can kind of seamlessly step in, to manage that. And so, the different hats that person's going to wear when you're no longer here, typically the guardian, of the property we refer to as a trustee if you're leaving the assets to your child. So that's an extremely important role when doing planning for a family member who has special needs. And I think, I see this in my practice with folks with special needs and no special needs, right? People, they come into my office and they've done wills and they've set up trusts, and I say, okay, well, why did you name this person? And it's almost like very little thought, oh, well, it's my child or it's my best friend. And, really not going into or a lot of thought given to the expertise they're going to need and what their role is going to be. And I actually yell at my associates all the time. They'll come to me and say, oh, so-and-so wants to appoint this person. And it's like, why are we listening to this? They're coming to us for advice. If they wanted to do their own thing, they should go on, legalzoom.com and draft their documents. We know what works. We are in this day in and day out. And so our job is to really tease out and think about and talk through and come up with a plan. And particularly for a child with special needs, it is very rarely appropriate to have one person in that role. The needs for that child is going to be very, very multifaceted. And so, while maybe the parent who is the advocate and dedicating everything to them, they still have support, right? They have professionals that are supporting them. And so, in our view, and Laura and I have spent, a lot of time on this, is really the more team approach we find is best for those roles.
Okay, I want to back up a little bit, all right, and try to make this a little bit more understandable for everybody. Okay, let's say that I had a child who was a teenager. I am a 60-year-old something, 60 something, and the child was 19, and clearly had special needs. People like that must come to you all the time, and they must be heartbroken. And I say that because I know that how difficult it was to send my two perfectly healthy kids off to college. Okay, heartbreaking, because I didn't have the control anymore that I thought I had. And I didn't have much control anyway, it didn't really matter. So what kind of heartbreak do you see? And how do you deal with the human aspects of asking parents or other loved ones to give up control? How does that work? Can you guys address that?
Sure.
Laura?
Yeah, sure. So it's a really important question, Joe. So first, let's start by understanding that in New York State and in most states in the country, when a person reaches the age of 18, they are automatically an emancipated adult. Their medical or mental status is not considered under the law. So even your most severely disabled nonverbal child will be an emancipated adult on their 18th birthday. So what happens after that is greatly determined by what their skills and abilities are, as I mentioned earlier. For a severely disabled, let's go from this example, it's easier, of an individual who really can't manage anything on their own, can't communicate with third parties, can't manage their own daily care needs. A guardianship on the 18th or around the 18th birthday is very important. So we will start that process. And the way that I deal with the frustration, I think that's the word I would use most often, heartbreak for sure. For parents whose child has been disabled probably since birth, in most of these severe cases, they've come to understand that this is the spectrum of their lives and of their child's life. So my most important role is to reach out for somebody like Charles at that 18th birthday and try to help the families understand what life looks like once they can no longer care for their child, for whatever the reason, whether it's their own age or incapacity, or whether it's just time for the child to move on to a more social environment. We spoke about this the other day, Charles and I, about how important it is for an individual with special needs to be in a community of other people with special needs and not to be necessarily isolated at home with their elderly parents, because there are a lot of non-tangible benefits to living in a community setting, just like those of us who went to college and lived in a dorm room or studied abroad and met new friends. There are intangible benefits to being in a community of individuals, and there are often better supports. Groups like Mary Haven offer such a wide variety of support mechanisms that parents, even doing their very best, often can't provide in a one-on-one setting at home. So we use the heartbreak to say, let's look forward and make sure that whatever you've done as a parent to support your child, we can replicate for you when you're no longer capable of doing it. And I know that organizations like Mary Haven do that every day, Charles.
Charles?
Yeah, that's well said. And I have plenty of experience in dealing with families who are screening their loved ones for placement. And it's heartbreaking. And you're hoping at some point families will see Mary Haven as an extension of the family. And that's what we aim to do. So we try to instill in the families the notion that we want that loved one to see Mary Haven as home eventually. And families just want to feel comfortable and know that their loved one is going to be taken care of for a lifetime. That's typically my conversation with parents, older adults these days. As they age, they want to know that the loved one is being taken care of. So, we're in the business, as Laura alluded to, of habilitating individuals. And sometimes when families have loved ones in the home over a period of time, they lose skill sets. They lose an ability to socialize as they would if they were at a provider like Mary Haven. So our goal is to minimize the stress of this entire process of onboarding into an agency of this type. And I think that we have a good reputation as doing so.
Mary and Laura, I'd like to ask you about special needs trusts. This is something that has come up. I imagine it is pertinent to disabled individuals. Can one of you address that and talk about why that's important?
Yeah, so, a special needs trust ensures, and first of all, there's two types of special needs trusts. The ones that we primarily deal with are what we call third-party special needs trusts, meaning somebody who has assets is establishing a trust and wants to give money to their child, let's say, So that's what we call a third-party special needs trust. The other type is if the disabled person, let's say, was, got into an accident, and because of this accident had this big trauma and won a lawsuit, they would establish the trust for themselves. That's what we refer to as a first-party special needs trust. But by and large, our practice, and I think, what your listeners, worrying about caring for a special needs one are really focused on the third-party special needs trust. So it's a trust that when you have a special needs child that you want to give assets to, you want to ensure that those assets can be used to supplement and provide for that child in a way that the government programs that they may be receiving benefits from cannot. And you also don't want this the inheritance you're leaving them to disqualify them from those programs, right? And so whenever you have a special needs child, you want to make sure whatever inheritance you're going to give them when you're no longer here is going to be protected in a special needs trust. Laura, I don't know if you want to.
Right. So Mary and I intersect in our practice areas in something she mentioned a minute ago, which is government programming and benefits. So programs like Charles and others throughout Long Island, some of the individuals who access those programs need to have Medicaid eligibility, different than Medicare or other programs that elderly individuals take advantage of. Medicaid is a government entitlement program. And because it's an entitlement program, there are set resource limits. Individuals must be below certain asset limitations in order to qualify for the program. So if a parent were to leave outright distributions to their child when they die, the child could either become ineligible for the program or remain ineligible for the program without the use of a special needs trust. If the assets are left in a trust, more than likely we can keep the child eligible. That's essential because there are many programs in New York that generate, eligibility is determined through a Medicaid approval process. And if you don't have Medicaid approval, there may be certain types of programs that are not available to your child, which we would want them to have as a baseline, as a standard. For example, for individuals who can work and who have varying differences or abilities, we would hope to have supported job placement or some other job coaching or other long-term plan to have the child have a productive life, as productive a life as possible. Many of our very good job training programs come through a Medicaid waiver program. And so your child has to be eligible for that program in order to take advantages of those services. So even individuals who have more than the required resources can potentially qualify for these programs, and we want them to stay eligible to give them the greatest range of ability, greatest opportunity. And it's important for Long Island listeners to know, New York, though there are frustrations with the system that are understandable, New York is one of the most generous states in the country when it comes to programming for disabled individuals, especially intellectual and developmental disabilities. And so staying in New York and staying eligible for the plethora of programs that we offer is a really important part of any good special needs plan.
Because this is an in-state question, is it not? Because the laws of New York State are the ones that are impacting people in New York. It might seem obvious, but you can't move to Florida and get the benefits of New York. Is what
That's an important distinction, Joe. We have many clients who, let's say, spend half of the year in Florida, or their child comes with them as they go in and out. You have to establish residency in order to get programming or eligibility. Certainly county resources, you actually have to establish county residency, driven by your Nassau or Suffolk or Queens residency. The programs are promulgated by the federal government and paid in part by the state, but are largely funded by the county where you live. So if you move to Florida, Florida has a history of very poor programming and support for individuals with intellectual or developmental disability. It just doesn't have a well-funded program. You can pretty much guarantee if you live in a state with low or no income taxes, the programming is not going to be available. So we pay a lot of income tax to live in New York, and as a result, we have a greater availability of programming.
Well, it goes for schools and roads also. Can someone also just touch upon where that line is, where you have an inheritance that comes to someone who is a disabled person, okay? And the parents die. is there some number that's going to kick them out of the state program? And can you give, and like, does the special needs trust that we are discussing, does that protect the money in some way? Can you guys address that?
So I'll start with the number and then I'll throw it to Mary. The number is $16,800. That's the Medicaid, that's the federal Medicaid threshold. You have to be below that number in order to qualify for a Medicaid program. And shielding it, the way you shield it is through the proper use of a trust. So I'll let Mary talk then.
Okay.
Yeah, and just so our listeners know, so Laura, her expertise is with guardianship and special needs, and I'm more of a general estate planning attorney. And so when my clients come to me, and I work exclusively with high net wealth and ultra high net worth families. And so they come to me and they think it's crazy. You know, why would I ever need, my child doesn't need programming. We have a lot of assets. We can, you know, pay for everything that they need. We've worked hard and this is what we want to use it for. But as Laura touched on, you know, there's program and access to that money cannot buy. And so there is no limit to how much money you have where we would not recommend a special needs trust for your child. And we draft them in a way sometimes they'll spring into effect depending on, you know, you may have a child who's not getting any government services right now and doesn't need that protection. But you think things may not always be this way. They may, you know, especially different types of illnesses where it may be degenerative later on. And so there's ways around that, but I would just say there's no upper limit to when a special needs trust is not appropriate. And I think that's a common misconception that, you know, some wealthy families may have.
Okay, you guys you talked about a number at 16,000. So let's talk about ultra medium needs people. Okay, let's say someone gets $100,000. Okay, in this thing, we were just talking about millions and such. What if it's 100 grand or 50 grand? Oh, that's over that number. What about the middle class? How does that work? Is it the same?
Charles, I think you can touch on this too from Mary Haven's perspective of a person who has the 100,000. There are options available to get that person to qualify if you can spend down appropriately.
Yeah, which I have to say, for our providers, very difficult. And we've had circumstances in the past where families have not necessarily been forthright about asset distribution, and we've had Medicaid benefits jeopardized as a result. So we will work with the families to the best of our ability to see if we can establish perhaps a pre-needs burial account. But we don't have real options to the extent that $100,000 would require. So we ask that families are very forthright about any potential assets that are coming to that individual over time.
What Charles is touching on, actually, Joe, is another really important point, which is it's great for the parent to go to the estate planning attorney like Mary and make sure everything is set for the parent's assets. That message has to be shared with anybody who might leave assets for a grandchild, a niece or nephew. If Mary does a perfect plan for your child and the parents' assets go into a trust and they're living in Charles's facility in Maryhaven, but a cousin leaves $100,000 directly to the child, the plan is foiled because that 100,000 will come in. That's where I might come in and work with Mary to say, there are programs. We could put that money into a pooled asset trust. We could put that money into an ABLE account. There are various programs in New York State that we wouldn't love to put that much money in there, but we could put it in and that money could be used over the course of time to supplement or support the special needs individual as they go through the programming. They could also do the type of trust Mary mentioned earlier. They could create a first party special needs trust with that money so that they could then regain their eligibility. But as Charles mentioned, if a person is in a program getting a Medicaid waiver service and they receive the money, there will likely be a disruption. There will be a loss of coverage, maybe even a loss of medical insurance. Mm-hmm. And when the parents are no longer here, we all underestimate how much parents do to keep their kids eligible and to keep them moving. Getting back on the Medicaid program is not that simple. And so you would need an advocate or some other person, an attorney or a social worker, to really guide that process. And when the parents are no longer here, it becomes even trickier, which goes back to what Mary was saying earlier, which is you need to build a bigger community around your child. parents are superheroes and it's lovely, but they need support and the child needs support beyond just them. And so we would want them to think about using social work services or using Mary Haven or some other organization that may have advocates already on staff who can deal with Medicaid interruption. But it can all be avoided. Those problems can be avoided with appropriate estate planning.
Mhm.
So for those clients that are kind of the middle class, let's say, yeah, they need these special needs trusts, and it's just important for them to do that because, you know, their money is, you know, they want every penny of it used for their child. So it is very important for those folks to do this type of planning.
I want to alert the my support team that we're going to go 10 minutes over. This is far too important to leave short. Can we talk about, from the legal aspect, why it is so important? And you're touching on it, but I want you to hammer it home. Why it's so important to talk to a lawyer who knows what they're doing in this area. Mary?
Yeah, so, you know, I think I always say estate planning in general, you need to speak to a lawyer that just says, as Laura says, if they can do anything else, they can't do this well. Laura and I are even so specialized that she deals on, you know, exclusively in the special needs world, and I'm dealing in the estate planning world. So that's how kind of ultra specialized our firm happens to be. But you know, it's extremely important to be with a knowledgeable attorney. And you know, I have folks that come to me all the time. It's like, I spend a lot of money. You know, what do you mean this doesn't work? You know, this was a lawyer. How do I know? And you know, I would say use your advisors, you know, accountants, your financial advisors, you know, look, you know, what lawyers are kind of lecturing to other lawyers, what lawyers are teaching this, right? Because it's kind of hard, I think, for a consumer to know. I think with in the medical field, we think, oh, I need to like double check and go for second opinions. Whereas you hire a lawyer and you don't think about them being really specialized, and we truly are. So I would absolutely, if you have a special needs child, you must go to somebody who only does that, who is ultra specialized in that. I think that's, you know, and unfortunately, and we see this all the time in estate planning in general, people do these documents and they have no idea that they work or don't work because they don't come into effect till they're no longer here, right? And so they think, oh, my lawyer's good, these documents work, and it's just a very, you know, unfortunate situation because you may not know what you're getting. And so the best way, as you know, lay people, how are you to know? You're trusting an expert. I would say, you know, ask communities around you. Do people have, you know, who have a lot of experience and come referred by many different people, by many experts in the field.
I wanted to address, no, go ahead, Laura. Go ahead.
I would just add that it's important to have specialties because of the intricacies of, let's say, the government programming, for example. Medicaid as a program is the most complicated, complex scenario. It used to be very user-friendly. You could walk into a Medicaid office, do the application yourself. It's really not like that anymore. And in the 20 years I've been practicing, it's very different from when I started. So I can just say that doing it incorrectly will cost you both financially and emotionally. If there won't be the return on your investment will be negative. You won't be proud or happy with the result. And it doesn't mean that it has to be much more expensive. It just means that the person, when they're looking at your loved one, sees all of the intricacies, let's say from the legal perspective. Could you get guardianship or not? Could you apply for Medicaid or not? Are you doing the right estate planning or not? Those are just so varied in their ability level that it would be hard to find that in a generalized attorney to have that level of specialized knowledge.
One question before we conclude is, we've been talking a great deal about special needs children or younger people. I'd like to just briefly address what happens when a parent or a grandparent becomes incapable of handling these serious matters from a personal standpoint. They can't take care of themselves. They can't make this financial decisions. In simple terms, okay, what are the steps that a son or a daughter should make with regard to taking care of their elderly, perhaps becoming sick parents?
And I would say, you know, that happens to many, many more families, right? Especially today within medicine, where people are living longer, but not necessarily having full capacity. And so, you know, hopefully your parent has put into place the necessary planning themselves when they had capacity, and have documents that allows you to step in to manage their finances, to make healthcare decisions, to make sure you're not being taken advantage of. That's, the importance of all of us who are healthy and well to get those documents in place. So God forbid that happens, you're ready. You've already picked that team that's going to come in and they can just simply step in. I think the real challenge lies when the planning has not been done, or when there's fights about it, right? Where the siblings aren't getting along and, one is trying to vie for control and maybe rip up the old documents. They don't like that sister was in and now brother wants. So it is absolutely very challenging, and something we see. The best kind of solution, as for many things, is preventative care, right? It is to get your documents in place so that you're not putting your children in that scenario.
Yeah, I would say, Joe, that the first step would be, like Mary was saying, if you're experiencing illness with a parent, first do your best to find out if there are estate planning documents in place. If there are not, the next appointment you make should be with an elder law or estate planning attorney. The third thing would be to try to get an understanding of their finances as quickly as you can. Where do they bank? Where do they file their taxes? Who handles their homeowner's policy? Get as much information about the finances and the workings of the day-to-day as you can. And then, of course, and we put the legal issues first, but you appropriate medical care. Sometimes we find parents are not receiving appropriate medical care. They either can't make their own appointments or they forget. Make sure the medication is appropriate, check with the pharmacist that the doses are correct. You take a measured approach, and then when you have all of that information, you can decide. If, as Mary said, your parent is in a place where they are no longer capable of making decisions and they have not done estate planning documents, then you'll need a guardianship. You'll need to go through that mental hygiene process to get guardianship. And I'll tell you, having done many of those in Nassau and Suffolk County, we focus largely in that area here in my group. It's a very tedious and expensive process. So to the extent you can avoid it, we have to. It's a mandate. We have to, as a state and certainly as a local community, try to avoid it.
Charles, because of the way the time is going, I think this is going to be a perfect way for you to wrap it up for us. My question is pretty simple. You must see an awful lot and a spectrum of issues. Can you tell me what you've learned and if there was one thing you'd like to express to the families out there who are facing these various issues, what would that be?
Yeah, I've learned over the years, speaking with hundreds of families, how difficult it is to care for a loved one in the home. And frankly, I would suggest that they reach out. I've had numerous families in the community call me, sometimes when it's too late, or when, as Laura and Mary have suggested, could be done earlier. You have help. There are resources out there for your loved one. And I would encourage you to reach out to providers directly or your local regional office for developmental disability. I think you'll find that your quality of life will improve drastically, and that your loved one will develop skills and reach a potential beyond your wildest dreams, honestly.
Remarkable. This has been a truly enlightening session, and I know I've learned a great deal, and I believe our readers and viewers will as well. I'd like to now kick this back to our associate publisher, Jenna Natali, for a last word.
Thanks, Joe. And thanks again to each of you, Mary Pugh Riley and Laura Brancato from Meltzer Lippy, as well as Charles Vanek from Mercy Haven, for bringing your expert insights. So much to unpack, so much to still uncover. So certainly just the beginning of conversation for so many families, but starting the conversation, I think, is the most important part, right? So thanks to each of you, as well as always, masterful moderation by Joe Dowd. Be sure to mark your calendars for November 3rd. LIBN Now will be returning live once again with our co-presenting partners at Wellbridge Addiction Treatment and Research, as well as our friends at Ruskin Moscow Faltashek, to take a close look at addiction in the workplace and the alarming impact that it's made on this post-COVID workforce, and what employers can do to care for struggling employees while simultaneously advocating for a safe and profitable work environment. Check out those November 3rd panelists and register to tune in live at libn.com/libnow. Thanks again for joining us, and we'll see you on the next episode of LIBN Now, November 3rd.